after the coffee. That's great, because we'll have a fascinating panel on a core theme of the Pact, which is solidarity. And I won't introduce it for long. I spoke this morning. I will just say that we have five actually, excellent speakers. And the first one will be my dear colleague Francesco Maiani from the University of Lausanne, the expert on Dublin and solidarity in academic circles. And we have been instructed that the first speaker introducing the theme has 15 minutes. The others have 10 minutes. So Francesco, 15 minutes. Go ahead.
Excellent. Thank you very much, Daniel. I'm putting up a timer, so I'm sure that I don't mistake it. You said 50, right? No, 15. 15. Okay, so Daniel stated this morning that the Pact is half dead. Well, I don't know if clean burial would be perhaps the preferred approach, but whether we restart from a clean slate or discuss amendments to the proposal that is currently on the table, I believe that some radical departure from the current approach are worth discussing. It's better late than never. And given the limited time and the nature of the discussion we are leading, I will try to stick to a few fundamental points. The first point is that there is a very broad consensus among scholars, lawyers and social scientists alike, that refugee agency must be acknowledged and voluntary mobility must be allowed upstream or downstream of status recognition. By mobility, I don't mean token mobility, read long-term resident status directive as it currently stands. I mean real mobility, whatever the legal form, the concerned person should be, as a rule, able to rely on the fact that they will be able to rejoin within a reasonable time frame the social and personal context that is most supportive for them. This is actually the core idea on which European integration has been built, that free movement is the best allocating principle for both individuals and society. And accepting that this applies also to our common European asylum system and common travel zone would take much drama away from the Dublin process on the ground. It would stop many applicants fighting the system as they're doing now, and it would allow the administration to focus on rapid processing of the applications rather than on shuffling applicants around Europe. The current prohibitionist bureaucratic approach that is still embedded in the RAMM proposal and so deeply rooted in the mentality of the Council and the Commission has been conclusively proved to be a failure, and it is difficult to understand why we keep sticking to it. I would note as an additional point that the treaty more than hints at the dimension of mobility of at least beneficiaries of protection by evoking a status that is valid throughout the Union. Now, of course, we may spend a whole day or several discussing the detail of the new arrangements, and there is a vast range of options. The key point is it is way past time that we put this on the agenda of the common European asylum system. At the moment, even just extending the Dublin definition of family to siblings is fueling first discussion in Council. So we are still several light years away from where we need to be to have a productive discussion on this. Nevertheless, it is necessary. Second point, solidarity arrangements must indeed be developed, but they must be workable, and the trade-offs implicit in their operation must be considered very carefully. Not all forms of solidarity are the same in this respect. I will not discuss today sharing administrative capacities. It is a very promising front. It is an interesting dimension. There is much to be done, starting from mutualizing knowledge base, such as country of origin information and other aspects, all the way to joint processing. But in this, I would like rather to refer to Lillian's presentation and to her extensive work on the topic. just by noting in passing that this is a promising avenue which could take us far, even without a treaty reform. Sharing money. Much derided fiscal solidarity is the only form of solidarity that has basically no counter-indications. And it is still embryonic in the common European asylum system. We heard Iris Goldner-Lang describe to us in detail that there has been substantial increase, but the overall amount is, I'm quoting, modest. In essence, expenditures related to asylum are still on national budgets. Now, ask any political economist, and he or she will reply that this is pure paradox in an area without borders aspiring to have a common asylum policy. To be clear, it is not a matter of throwing some money at the problem. It is a matter of transitioning to a truly common policy where risks and expenditure are mutualized. Do you remember the common agricultural policy? Yes, that is what I am referring to. Now, to my knowledge, this has never been discussed. And I am told by some that it is impossible. Could we perhaps get a little bit of perspective here? We, as humanity, are required to overhaul our modes of production and consumption in a matter of years to avoid extinction. If we believe that reform of the EU budget is impossible, we are doomed. Okay? So this is a perspective that cannot be ruled out merely on the fact that it has not been done before. Now, coming to sharing people, which seems to be everyone's current fixation. As I said before, and as I've detailed on several writings, but I don't have the time to go into the details today, it is a no-go on principled and practical grounds. For those who do not buy the principled part, there are still the practical grounds. I am quoting a prominent expert in human geography, Etienne Piguet, who is a Swiss scholar. He has characterized this kind of exercise as a Herculean task when carried out in national federal systems. When it comes to making the same kind of play in a system comprising several member states as the European Union, we have rather strong evidence that it doesn't work. It is not feasible. Or it is feasible, but with very acute side effects. Widespread coercion, human misery, a flourishing intra-EU smuggler business, high budgetary costs for all the administrations involved, and last but not least, undermining completely the efficiency and integrity of asylum processes by pushing people underground or into endless legal proceedings. So this is the cost of having coercive mechanisms of sharing people, and it is sad to observe that we are not moving away from this kind of proposal in the debate. We never have, and we still don't. And if we look at what the Commission has proposed, it still relies on that very concept with three further shortcomings. The first is unpredictability, the second is labyrinthine complexity, and the third one is a near Orwellian level of bureaucracy injected into our asylum procedures. Of course, as many experts have said, starting from Heiko Thielemann quite some time ago in a deservedly famous study that was carried out for EU institutions, relocation programs that would rely on mandatory quotas for states but on voluntary adhesion on the part of the concerned persons, hold much more potential of working smoothly and of yielding useful results in terms of fair distribution. Of course, the EU would have to prove capable to hold member states to their duties. More on this later. But the discussion never gets there because we are constantly told that any concession to refugee agency and interest would create a pull factor. That's such an important part in the whole discussion of solidarity that it needs to be mentioned. we are paralyzed by the fear of creating a pull factor, except that what evidence we have, what scholarly evidence we have on these phenomena points in the other direction. The most prominent result of research carried out in the field in this area is that applicants are unaware of what distribution rules they will meet once they get to Europe. So how can distribution rules we have in force in Europe generate pull factors? This should be explained to us. And I believe it would be time to rid ourselves of this particular scarecrow, the pull factor scarecrow, which has been allowed to dominate the scene of EU policymaking for years and to paralyze any feasible solution in the process. That's about it for solidarity for me, but I see I still have got 5 minutes to go, and I would like to use them to turn to 3 meta issues that have much bearing on the solidarity debate. The first one is that Fortress Europe is not a fit place to negotiate solidarity. We've heard the argument time and again, explicitly or implicitly, that if we manage to stem the flows and close the borders, reduce the numbers, it will become easier to negotiate solidarity among the member states. I seriously doubt this. If the EU and its institutions condone or support the narrative that European states are pulling more than their share and can legitimately shut off their borders to, say, Afghan refugees, well, any share of refugees would be construed as too much nationally. In other words, promoting a niggardly attitude to refugee protection globally can hardly promote equanimity at home. If we are to have productive discussions on EU solidarities, EU bodies should be in the first line to reassert the point of view that inspired Tampere and the treaties. Europe has collective responsibilities which it must embrace, not shirk, on the global scene. And no, Europe is most definitely not shouldering more than its fair burden on the global scale. 2. In lawless Europe, a reform is futile. We've heard it several times today. There is entrenched non-compliance of EU law. That's not a minor issue. Disregard for basic EU rules on access to protection, on reception, on status recognition, or on responsibility allocation itself is poison for the integrity of any solidarity or distribution scheme that we might conceive of. And by the way, there is a close relation between the problems related to entrenched non-compliance and what I said before. I am quite impressed at the ease with which migratory states of exception are declared and accepted as justification for clear departures from EU and international law today. Side note, the Pact would not solve this problem. It would make it much easier through the force majeure proposal for member states to disengage themselves and say that there is a state of emergency which does not allow them to apply EU law. Third and last point, and it's a point we've heard several times today, it has been argued, not without merits, and it is not an unreasonable argument, that's not what I'm arguing. It has been argued several times that agreeing to a reform and to this pact would be a sine qua non if we are to see EU law respected. But if we think on the argument a little bit further, and this may be an interesting point of discussion with Daniel, there are at least 3 points that I would ask you to consider. The first one is that, as Catherine Woolard pointed out this morning, there is no convincing argument based on the content of the pact to show that the pact itself would improve compliance. Rather, to the contrary, there are parts of the pact that are problematic in this respect. 2, the argument boils down to accepting the argument that we either get the pact or we accept illegality, boils down to giving us the choice between accepting illegal practices or a reform that legitimizes them. Well, I'll have neither, but gun to my head, I prefer the first option, because at least I can fight illegal practices in court, whereas if they become law, there is no defense anymore. 3, and more fundamentally, if the EU is unable to obtain compliance with the law as it stands, and we're talking about acts that are less than 10 years old, we're not talking about the Bürgerliches Gesetzbuch, what good is it to reform that law? And what good is it to have EU asylum law at all? We cannot logically accept the argument that we need a reform if EU law is to be implemented without revoking into question the usefulness of the whole common European asylum system, I fear. We heard Mr. Schotter, and this is my very last remark to the chair. We heard Mr. Schotter point out that the Commission must tread lightly as an enforcer because of its role as policy initiator and broker. It's a good argument, but perhaps it means that it's time to take a break from the role of policy initiator. Between having a reform, having the Pact, and having vigorous implementation of existing law, I chose the latter every day of the week. We can resume talks on a reform once the basics are reestablished. Speaking of which, you would expect quite a few preliminary references from Greek courts in asylum matters. Where are they? Isn't there a problem there and elsewhere in the member state with access to justice and with the use of preliminary reference procedure? Article 13 of the TEU, Article 47 of the Charter, Article 267 of the TFAU. That would be a most interesting theme for a Commission inquiry. Thank you very much.
Yeah, thanks indeed, Francesco. We are academics, and in academia, argument, counter-argument, thesis, antithesis, that's what makes the world going. And I think that was an excellent example for it. And we'll proceed right away with Gaia Romeo, who is a consultant with EuroMed Rights, and we are curious to hear your views. 10 minutes.
Good afternoon, and thank you for inviting me to this conference. I also have a PowerPoint presentation. Maybe you can make it start? Okay, thank you very much. So the name of this panel is How and How Much Solidarity. And the other speakers in this panel have already or will later focus in details on the forms of solidarity among member states that the new pact wants to introduce. On my side, I would like to answer the question from another angle. What happens if solidarity doesn't work? What would be the impact on countries of first arrival? So, because it is my opinion and the opinion of EuroMed Rights, the NGO that I represent today, that this solidarity mechanism among member states will not work. And that's a second deception after we already buried our hopes that the word solidarity could actually refer to refugees and migrants. Okay. So, why do I say that the solidarity mechanism doesn't work? Well, first, the pact is very abstract, and when we try to inscribe it into a concrete framework, we realize that it's mostly infeasible and totally disconnected from reality on the ground. So my approach and the approach that I used with EuroMed Rights was to apply the pact to reality and to show what its concrete effects would be. So in my intervention today, I will try to show how the new set of border procedures will not relieve, but instead increase the pressure on countries of first arrival, and how the solidarity mechanism will not change it. So, for countries of first arrival like Spain, Italy, and Greece, one of the first practical consequences of the new border procedures will be that they will need to ensure that there is a sufficient number of places in closed migration facilities to carry them out. As it was already discussed before, while the pact never states that asylum seekers have to be detained before, because of the fictional pre-entry phase, the fact that asylum seekers will not be allowed to officially enter the territory of the member states and where they are, well, they will have to be enclosed somewhere. So I will just use the word detention to refer to this condition of deprivation of liberty, and I will call migration detention facilities all these kind of facilities where this procedure could be carried out. So official and non-official, like hotspots, for example. So Of course, this kind of detention facilities already exist. The question is, are the places sufficient to carry out the new border procedure? To try to answer this question, we calculated how many people would be detained in a certain year, and we compare it with the actual available places in migrant detention facilities. We simulated two different scenarios, so a regular situation and when the crisis mechanism is applied. As an example for a normal year, well, not a normal year, but a normal year for arrival of migrants, I choose 2020, because it's the most recent data that we have on a whole year, and because it has been a year characterized by quite low number of arrivals. While as an example of a crisis situation, I used Greece in 2015. So I did some simulations. How did I do them? So I picked data on monthly arrivals, and I combined them with nationalities, recognition rates from the previous year, and data of unaccompanied children. I know these are not the only criteria that should be used, but as it was also discussed before, a screening of 5 days is inadequate to correctly assess vulnerabilities. Anyway, please consider that what I present now should be considered more a reasonable estimation rather than precise calculation. So I will start with Spain. Okay, here we have some data on Spain in 2020. So in 2020, Spain had a quite low number of arrivals, 41,000, which is not very much. The 5 most common countries of origin, you can see them there. They all have a recognition rate which is lower than 20%. So on this basis, I calculated that the border procedures would have applied to 88% of asylum seekers. And here is the simulation. So there are 2 different scenarios. In both, everyone who arrives stays 5 weeks in detention to undergo the screening. Then we have an 18-week scenario, meaning 18 weeks as an average duration of detention. It corresponds to a scenario where half of asylum seekers are granted that status, and so they are released from detention after the asylum border procedure, while the other half are denied any protection status, so they have to undergo the return border procedure. The 24-week scenario is an extreme example of a situation where no one is granted asylum and everyone stays as well for the return border procedure. Since the recognition rate of those who undergo the border procedure will be lower than 20%, but we can imagine that some asylum seekers will be directly channeled to the return border procedure. I would say that a reasonable situation would be somewhere between the 2, but probably closer to the second one. Okay, so in the graph, I hope you can see it's not too small. So the red dashed line shows the capacity of migration detention facilities. The blue line shows the arrivals, so those who arrive into detention. And the orange line shows those who get out from detention, so those who are granted a status or those who are returned. The gray line in between shows the evolution of detentions. So as you can see, in moments of worst pressure, 25,000 or more than 28,000 people would be detained in the same moment. And the capacity is slightly higher than 4,000 places. It means that for every person, for every 6 to 7 person, there would be 1 place. Another example, that's Italy in 2020. So the situation is very similar. We have quite a low number of arrivals compared to before and after. The 5 most common countries of origin are all countries with a recognition rate which is lower than 20%. And on this basis, I calculated that the border procedures would apply to 78% of asylum seekers. So again, our simulations, again, the same 2 scenarios. In this case, more than 15,000 or almost 20,000 people would be detained in the same moment, while the capacity of facilities today is 2,307. So it means 1 place for 7 to 9 persons. A crisis situation now, so some derogatory rules applied in this case. Of course, that's an extreme situation. More than 861,000 people arrived in Greece in that year. As for recognition rate, the situation is different here because, as you can see, the first common nationality is Syria with 56%, and that's one of the not many countries that has a recognition rate which is higher than 75%. So on this basis, I calculated that the border procedure would have applied only to 43%, but it's still to 377,000 people. And that's the simulation. In this case, in moments of worst pressure, 376,000 or almost 400,000 people would have been detained in the same moment. And the capacity now is 11,000. So it means that for every person, there will be one place for 34 to 35 persons. I think these numbers speak by themselves. So the situation will be very hard to manage. Can we imagine what happens if you use the facilities that exist already? There's no space. But can we really believe that in a moment of crisis, Greece could just multiply by 35 its places in migration detention facilities? Then it is not my focus today, and other speakers have already talked about it or will go to it after, but life in this kind of closed facilities is deplorable. Life conditions are deplorable, and human rights and procedural guarantees are not respected even today when the numbers are much lower. So what would happen if we multiply these numbers by 10, by 20, by 30? I didn't put it in the slide now, but I did a crisis simulation on Italy too, and the relation is 1 to 50. So we can really hardly imagine what the human impact of the new procedure could be. The solidarity mechanism will not have an effect on that, because relocations didn't work, even when they were compulsory and on a much smaller scale in 2015, 2017, because sponsor returns and other forms of solidarity will only partially relieve first countries of arrival from the duty of carrying out the border procedures on their national territory. Moreover, as it was also already said, the MFF probably will not cover the expenses of the new procedures, or at least we cannot be sure that its financial implications have been taken into account. So, in conclusions, countries of first arrival, like Spain, Italy, Greece, but also Malta and Cyprus, they will keep having the practical and financial burden of the asylum seekers arriving on European shores, and the crisis mechanism will only worsen the management of crisis situation rather than improve it. So I speak here as EuroMed rights. With our members, we won't stop trying to show what the real effects of this pact would be, that the solidarity mechanism will not work, that there will be no solidarity neither for refugees in need of protection, nor for countries of first arrival. And I will end here, because I think my time has almost run out, but thank you very much for your attention, and I wish you an excellent continuation of this conference.
No, thanks indeed, Ms. Romeo, for this very insightful presentation and the calculation behind it. We'll discuss it after the other presentations, and we'll continue with the famous or infamous return sponsorships. Florian Trauner from Brussels will speak about.
Thank you, Daniel. Thank you for having me at this interesting conference. I've also prepared a PowerPoint. There it is. So I will talk about the concept of return sponsorship. Return sponsorship is one of the more novel elements included in this new pact. It's part of this idea of having mandatory but flexible solidarity, so that states no longer are only obliged to show solidarity through, in particular, relocation of asylum seekers, as it was a main focus in the not successful Dublin IV proposal. So right now it should be more, or the idea is to have a more flexible bandbreadth of solidarity mechanism, and return sponsorship could be one of them. So to make it less abstract, I thought I will start with a concrete example, how it could look like if it's applied as it is standing right now. So let's say there is a group of Nigerian migrants to be returned from Sicily. They are found to be ineligible to stay. Belgium acts as the return sponsor. So the idea is that the migrants do remain initially in Sicily in this case. The legal responsibility continues to be with Italy. The Belgian authority would come to the Italian authority and ask, what can we do to make a return happen? Italy suggests, let's try to get laissez-faire documents, let's, for instance, propose an assisted voluntary return scheme so that the migrants take up such an offer. There is the newly created position of the return coordinator that is supposed to facilitate the negotiations between the Belgian and the Italian authorities. Two outcomes. Return is possible. So migrants are directly returned from Sicily to Nigeria, possibly with the help of Frontex, which is having a quite increased return capacities. Second possibility is that the return is not possible, and in this case, migrants are then transferred to Belgium after 8 months. This time period could be reduced after 4 months to 4 months in the case of a crisis. The obligation for these migrants to return or to be returned does not cease with a transfer within Europe. Belgium may continue trying to return these people, or eventually other national laws, regularization on an individual basis, a toleration regime, whatever, may kick in. So that is the basic idea of this concept of return sponsorship. What is the background? How did it come into being? There are 3 challenges that the Commission thought to tackle all at once with the concept of return sponsorship. One certainly is the relatively uneven distribution of asylum seekers within the member states. A known fact among a group of experts such as this room. You have states that had much more asylum seekers than others, and you can see, if you look a bit over the years, that the numbers fluctuate to quite some extent, depending also on national measures, on and so on. So the distribution is very uneven, and the EU has seen that mandatory relocations do not work very well. So we have this famous emergency relocation mechanism, which was supposed to relocate up to 160,000 migrants. De facto, the Commission aimed for a much smaller number. But you can see then, in terms of implementation, that some states did relocate quite some numbers of asylum seekers to their home countries away from Italy and Greece. Some other states, Hungary, Poland, but also Austria, Slovakia, they did really very few, they relocated very small numbers, let's say it so. So other states did not live up to the expectations that the Commission had in them, and the idea to move emergency relocation scheme into a permanent relocation scheme was one of the most controversial points of the Dublin IV proposal. Hungary even had a national referendum on the issue, and it was one of the main points where it was not adopted, the asylum package. And the third challenge is a relatively low return rate. So this is a figure that is coming from a research project. In this research project, we looked at the return rate for the whole world over a period of 11 years. This is the average, but it's relatively also known for the member states and the Commission that the return rates differ quite substantially depending on region where you look like. You have some countries that do cooperate quite closely with the European Union, some states that do not cooperate a lot. You have very low numbers of migrants being returned to some region in Africa in particular. So return has moved more to the center of the EU's attention. So the return sponsorship should bring this all together. The Commission, as Thym said in his blog post, is a realpolitik approach. Commission thinking, if some states are not happy with relocation, ask for very restrictive migration measures, then let's give them the responsibility to take care of return, large-scale return. Return sponsorship is the expression of this. Some states can do more on relocation, some states can only concentrate on return, some states can do a mixture and some operational measures, so on. But the question is, can it work? So there are different challenges, politically and human rights challenges. Politically, it's probably more shifting the cleavages of political of the member states than really solving them. For some states that have been opposed to relocation, they continue to be opposed right now to the return sponsorship. For them, it's, as it's also in the media being voiced, it's a kind of a relocation through the back door. After all, you need to take physically migrants away from EU first country of entry to other states. And for other governments, in particular than the Greek, Italian and Mediterranean governments, it's not far enough. It's too vague. The solidarity provisions needs to be strengthened, and to refer in particular to the point that 4 or 8 months, 4 months in a crisis are far too long. They would go for much shorter time periods, 4 months or shorter. This is the first fourth line, let's say it so. The other point is that there is a lot of flexibility inbuilt in the concept. The Commission gives member states the choice to choose which migrants they want to return, so they can choose nationalities. They can choose how much they focus on return, how much on relocation, how much on operational support. So if you really look in this, I mean, the Commission says we need probably this room of maneuver to come to a compromise. De facto, it's implying that there are a lot of ad hoc negotiations, a lot of possibility to shirk responsibilities, and given the experience that also member states had with the relocation scheme, there is a quite high expectations that after all, member states of first entry will have higher responsibilities than the others. The other challenge is there are quite some vulnerabilities for migrants. It builds upon, to a certain extent, the assumption that there's a common return system, policies in Europe, but we have seen that member states' practices, for instance, regarding the assessment of how safe the situation is in certain countries of origin differs widely. There is very clear line of accountabilities if a sponsoring country is taking responsibility for flying people back, who is in charge if something goes wrong, and so on. And human rights standards presumably relatively challenged by this whole concept, let's say it so. And the final point is the idea that third countries will do more as well. Otherwise, the issue of, I mean, the ideal outcome of the Commission, from the Commission's point of view, is that there are very few numbers to be returned from states because they are all very quickly brought back to the country of origin or transit. The Commission and the EU points to these new possibilities under the visa code, saying that there could be negative visa restrictions if third countries do not cooperate more on return and readmission. Bangladesh, Iraq, and Gambia are right now the first 3 countries affected by this rule. But these states, okay, on these states, the member states probably don't have very high stakes, but on key countries of origin and transit, some member states do have much higher stakes. Think of France and the military operation in the Sahel and all the things. So it's really a question if these key states will risk their bilateral relations with some countries of origin while they have very strong stakes in other fields there. I'm already coming to the conclusions. So the point of departure to understand the concept of return sponsorship is that return is being moved to the center of migration management, is seen as the missing piece. It's certainly a realpolitik approach, acknowledge the what is possible. It has relatively high stakes in terms of politicization, in terms of human rights safeguards, and there is a certain risk that it's too optimistic on what could be achieved with regard to third country and with regard to the cooperation within Europe. So that's already from my point. I just mentioned 3 readings. Isabella Meicher wrote a very nice piece on the return system under the Pact, and the 2 papers that I co-authored on the points that I made. Thanks a lot for already.
Thanks indeed. And I can only recommend the papers written by Florian. They are really excellent read and worthwhile. And we'll continue with 2, which I understand, spontaneous comments. The first one by Gabriele Palermo, who is General Director in the Ministry of Foreign Affairs in Rome. And he joins us via video link live from Rome. It's great that you are there. And the floor is yours for the next 5 to 10 minutes.
Okay. Good afternoon, and thank you, Chair, for the floor. I would also like to thank the Odysseus Network for giving me the chance to take part in this very interesting panel, where a number of interesting points has been raised. So I would also like to thank the 3 previous speakers for their presentations, which have given me some food for thought, as is said. And one of the key takeaways for me from the 3 presentations as a whole would certainly be the complexity of the issue that we are discussing today, and the complexity of the proposals of the Pact as well. We should keep in mind that today in this panel we are only discussing a part of the new Pact on Migration and Asylum, even though it's a very important one, of course, but it's a part of it. And there are already a number of practical and operational and legal questions that have been raised that are very important. And this is also related to the of course, to the complexity of the work that the European Commission has carried out in drafting these proposals. It certainly must have been a rather massive undertaking writing these proposals that are so complex and so also coherent and intertwined. And as far as solidarity is more specifically concerned, our position is that the proposals of the Pact, especially the Asylum and Migration Management Regulation, do contain some principles that are welcomed by us. That is the establishment of a permanent solidarity mechanism. And we also, there is also the explicit recognition of the specificity of search and rescue operation at sea, which, as you probably know, is a very important point for Italy. But on the other hand, when it comes to the actual provisions regarding solidarity, we see that the proposals are perhaps too vague. As other speakers have said, we have the impression that there could be a lack of predictability as far as solidarity is concerned. And then, of course, we would prefer a stronger, more prominent role for relocation measures, as we consider them the best way to really help with the issues that frontline member states face when they are faced with arrivals, especially when they are in large numbers. And another point that I sort of took away from the second presentation is how really intertwined the different parts of the Pact are. That is, of course, the issue of solidarity is also linked to the issue of border procedures, which is another a very important part of the Pact. And as far as return sponsorships are concerned, I listened to the presentation with great attention. And of course, returns are a very important topic for us. Our Ministry of the Interior, La Margese, has often spoken of the need to create a true EU return mechanism, a shared EU return policy. But so we would certainly appreciate measures that enhance cooperation on returns, but there are still a number of issues that would need to be clarified regarding this mechanism, especially the fact that there is also the issue of the cooperation from third countries, as was highlighted in the third presentation. So I think this could be it for now. Thank you very much.
Oh, thanks indeed for this very diplomatic intervention. I'm sure we'll have plenty of things to discuss later on, and you will of course have the opportunity to intervene again at the end. And the next commentator will be Antoine Thillaye du Boullay. Great name. And the floor is yours, and I apologize for the mispronunciation.
You don't have to, I'm used to it. But you can call me Antoine, it's always easier. Okay, so first of all, I would like to thank the Odysseus Network and the Egmont Institute for inviting me today for this conference. So they invited me in order to share some insights on the discussion within the Council. I'm not there to defend the Belgian position or any other position, because I'm not a Belgian representative anymore. Indeed, I used to work for the past 4 years within the Commissioner General for the Refugee and the Stateless Person, and as such, I was tasked to be a member of the Belgian delegation to the Asylum Working Party. So how can I say that? I've read the document, I've talked about the document, I've bargained all the documents, I've dreamed of the document, I've had nightmares as well of them. So I know them a little bit, but don't expect a brilliant intervention, because I'm not an academic, so I will be slightly less eloquent. So I have divided my my intervention in 3 parts. I would like to talk a little bit about the qualified majority, quickly as well about the content on the solidarity debate, and then I would like to share with you some pragmatic thoughts on the solidarity within the CS. Indeed, I took the initiative to broaden a little bit my intervention. It will not be only on solidarity, because even though solidarity it's at the key of all the discussion, but at the center of all the discussion, but is interlinked with other things. So the qualified majority. I know that unfortunately I wasn't there before this panel, and I heard that someone from the council said something about the qualified majority, and it seems like my point of view will be contrary. Indeed, so as you all know, since the Lisbon Treaty, there was the possibility to vote or to adopt all the legislative proposal on asylum with the qualified majority. But even though there's this possibility, there was a gentleman's agreement among the member states not to use it and to always find a consensus. And it was extremely important, and it's justified by the sensitivity of this matter. But there was this first trauma of the adoption of the Council decision in September 2015. And so, yes, after that, there was all the consequences that we know. Unfortunately, the relocation scheme wasn't a great success, not only because of the lack of willingness of the member state, but as well because the threshold that was in the relocation scheme was extremely high, Indeed, it was, if I remember well, a recognition rate of 75%, making de facto that most of the applicants in Italy were out of that scheme. It's huge. But then after that, so we went back to the consensus approach, and indeed it was said again, in many conclusions, and I think the last one was from the European Council in June 2018. And since then, indeed, it's there, but I believe that within the Council, there is a shift of mind to the qualified majority. And as a proof, as you all have heard, there is a political agreement on the EUAA, and this political agreement was found within the Council with the qualified majority. We still have to see the final vote, so member states can still change their position, but so far, in the discussion in the Council, it was the qualified majority who prevailed in order to agree on that negotiation with the Parliament. So what about the solidarity debate? It has been said by my former colleague from Italy. Indeed, you can't speak about solidarity without speaking about the responsibility. One cannot come without the other, so it's always there and will always be there, even though, if I remember well, with the new Pact, the Commission has tried to explain that we should change the way of thinking and not speak about solidarity and responsibility, but it's always there, and it will be always there. And indeed, so the main bargain chip, if I may say like that, within the Council are the border procedure and the solidarity measures that are provided in Article 45 of RMR. What else? So about the position within the Council, there are mainly three big positions. I believe you all know them, but it's always good to remind them. Indeed, on one side, you have a group of member states who want to have an automatic transfer mechanism for all applicants, and on the other, and on the side of responsibility, a voluntary a make clause for the border procedure, basically, as it is right now in APD. In the middle, you have a group of member states who accept to have a structural mechanism for transfer, but with different modalities. And on the side of responsibility, a border procedure that is a mandatory border procedure. And then you have the last group that want no transfer at all. And when I'm saying transfer, it's because indeed I could say relocation, but it's not only that. As it was explained, the concept of return sponsorship has been explained by Professor Troner. But at the end of that, of those 8 months, there is a transfer. So at the end, that's why the Visegrad group were explaining that it's a relocation by the back door. And of course, for them, on the side of responsibility, it's a mandatory border procedure with detention and so on. So I'm not going to dwell on these different aspects because it's way too complex. There are so many things that are still not understood, I have to say. For a year, we have discussed about the new Pact, and lots of those discussions were just explanation from the Commission for us to understand what it was. And I believe it's still not clear, as you have said rightly before me. So I'll go back to the qualified majority and to the different position of the member states. As you can see, there are two positions that are totally antagonistic. And I don't see the way for them to be able to meet in the middle. And so a consensus cannot be found. And that's why I believe that member states are forced to think about the qualified majority, even though they don't want to. And especially they don't want the consequences that maybe that I believe were mentioned at the very beginning. And so my last point will be about some pragmatic thought on the CEAS in a whole. I don't know if it was said before, but I will still share with you some of my idea. And one of them is, we said before that the CEAS was on the verge to collapse, but it didn't. It didn't so far. And even we can see on the ground that there are improvements in certain aspects. And I will just use one example. It's the Greek asylum system. In 2015, there were an extremely young administration with no capacity whatsoever. And now it's totally different. They are able to deal with a great number of asylum claims, even though it's not enough, I know. But still, we should congratulate them for that. And of course, it would have not been possible if they would not have received the assistance of EASO, other member states with deployed experts and financial means, of course. As well, when it comes to relocation, even though the mandatory relocation scheme doesn't exist anymore, voluntary relocation still exists nowadays, is still implemented by willingly member states. As well, on the legislative side, we are going to adopt the EUAA, and it's an excellent thing, especially for the operation on the ground, and as well the monitoring system. That is going to be something very interesting, I believe, and especially to have an objective discussion on the CEAS. So my point is, maybe the solution will not be found on the legislative side of the CEAS, but we could still try to improve the CEAS from the bottom to the council, maybe. And so I believe that maybe it's not strong enough to cope with a new crisis, but at least the CEAS is slightly stronger than in 2015. Thank you.
Merci, Antoine, for this very precise and eloquent presentation. We have plenty of food for thought, and in line with previous panels, we'll give the opportunity to our online participants first to intervene.
No, for the moment, we don't have a question online.
Okay, so it's after already in the afternoon, so we start here in the room. We start with Madalena. Please raise your hand so that I can see all of you, but Madalena, go first.
Yeah, thank you to all the speakers. Great presentations. I have two questions for Florian and then a follow-up to Francesco. To Florian, I was wondering if you could explore a little bit more on the impact of the return sponsorship on the existing bilateral readmissions agreements. There's several of them, and of some of them I know because of interviews, but actually it's very difficult to find a public information, transparent, that lists all the existing bilateral readmissions agreements between the member states. And then a second question that is like basically an invitation to expand a little more on the likelihood of third countries' cooperation, given the sanctions for lack of cooperation that were introduced as part of the recast visa code proposal. So we had the first assessment of the cooperation with third countries on the basis of Article 25A, but again, the assessment, I mean, I've read the communication from early February 2021 of the Commission, but the actual report is not public. And it's very loose language, and it's not very clear when such sanctions could be actually enforced. And how much actually this will force third countries to accept whatever it comes in terms of returns. And for Francesco, I don't have actually a question, but actually an answer maybe. So I totally agree with the roles that you're proposing, because you're putting these very important questions, like what role should the Commission play, guardian or a guardian of enforcing or policy broker. And then you're giving examples from Greek courts, for instance, you know, like maybe the enforcement should be actually closer scrutinizing in frontline countries, and the example of Greece. And it's true, although there's so many issues, we don't find any preliminary references for preliminary ruling from Greek courts. And I remember there's a good chapter written by a Greek judge in a book that I've edited with Galina and Philippe. And his impression is that the use of the 267 TFEU procedure is just cumbersome for a judge who's actually having to face a numerous amount of files. Now, that does not mean that they don't enforce EU law. You know, like the lack of, as Daniel Thym was saying, lack of judicial dialogue does not mean a lack of implementation of EU law. So it might be that there is an implicit judicial dialogue between that. But I actually wonder whether, you know, the use of 267 will solve the problem when we had the reply of the Court of Justice in X and X in the humanitarian visas and others, and also with the statement with EU-Turkey. So I wonder how much would actually change to have judicial dialogue. So thanks, and sorry for the long comments.
No, thanks indeed. Please raise your hand for the other questions. We won't get back to the answers yet, because if we start with the answers, we will have no more time for questions. But I have one question which will be posed by one of the participants, Francesco, but only the question, not the answer to the other comments yet.
Already? Wonderful. So we talked about, it's a question to Florian. I've got my opinion, but I'd like to hear his. What is the purpose of return sponsorship? Meaning, let's take it from this angle. From the perspective of good management of movement of people in the Schengen area, what purpose is achieved if we move those group of Nigerians from Italy to Belgium? What's the advantage? What do we get from this? It's a group of Nigerian returnees. They're expected to be returned to Nigeria. Instead, we organize the transfer from Italy to Belgium, which is not neutral. It means more detention, more handcuffing, more costs, more a charter flight, legal proceedings, you name it. And a lot of leakage, because intra-EU transfers are not more effective than returns. If you look at the statistics, there will be a lot of leakage. Okay. So we go to all this pain to obtain what? That's my question.
Thank you. I just have a very brief follow-up question, and it's also something on which I would just like maybe an additional clarification, because from my reading of the regulation, the return sponsorship would also apply to people who are already in the territory, so people who have been living potentially for years, including potentially families or even unaccompanied children, because there is no exception for that. So I think as a follow-up question is, how do you consider the risk of people potentially being transferred, as we said before, from Italy to Belgium, to countries maybe where they don't speak languages and where they have no social network, which we know is very important also for undocumented people who have been living in the countries. And then second to that is, I think, a big unresolved question, which is what can happen afterwards. Will people be potentially subjected to a no-return decision? Could people be detained again? Could people just be transferred somewhere and then just leave undocumented there? And is there also in the interest, I think, of what the Pact is going to achieve?
Who else? It's your opportunity to intervene in the debate. Galina.
No, I have a very brief question about something that I've been thinking about, and maybe you will have the answer. But in the RAM, there is also a provision for return sponsorship in relation to third country nationals who are not yet subject to a return decision in the benefiting member state. Now, I was just wondering how it would work in practice, because but you don't maybe know either. And a second thing I wanted, maybe that's also more a remark, but I got triggered also by when you asked what can be gained, and I thought these things, relocation, return sponsorship, they're kind of a formalization of secondary movement, and this contradictory discourse about secondary movements, and very much a lack of harmonization. So some states are just better in returning. Let's have them do it. Yeah.
Are they better?
Well, I mean, that's probably the premise underlying it. So some, bilateral relationships may facilitate return, and then, yeah.
Thanks. Thanks also for mentioning secondary movements, which I think hadn't been mentioned before on that panel, although it's probably a necessary part of the debate. Iris, you go next.
Yeah, thank you. Thank you for an excellent panel. I've enjoyed it. So my question is, well, I would say probably not really legal. It's, when trying to think of solutions, how to improve or enlarge solidarity in Europe, wouldn't the core of the problem seems to be that the EU is becoming more and more state-centered, right? So because each member state is looking at its own interest and interests of its own population as if, we are living kind of separate lives. So would the solution be more federalization? Again, more integration, and, we are coming back to the discussion that we have had for decades. Do we need more Europe, meaning more federalization? Because that would, in the end, bring more solidarity, because we would be forced to have more solidarity. And shouldn't we work more on something that we might call social solidarity, meaning, solidarity among EU citizens, which would then imply that the decision makers, policy makers, feel obliged to work towards their own population to show more solidarity at the political level.
Balthasar next.
Thank you so much. My question is addressed to Gaia. I was really impressed by your presentation, but the idea came up, are you the first to model the impact of the legislation proposed? Has the Commission not run a few model calculations? And if they have they come to a different result? If they have and they came to the same result, how could they dare to present the proposal?
A question by Florian.
Yeah, I have a question to Antoine, because you said yourself, you were not there, but you were much more positive about qualified majority voting than your colleague from the council in the morning. And his counter-argument was primarily to have a higher acceptance. It's so sensitive, so you need to have consensus to have the policies being implemented. You say right now it will sooner or later move towards qualified majority, it's already applied. Do you share this concern, or do you think it's a different kind of dynamic than in the implementation stage? Yeah, that would be my question. What's your counter argument to this?
If no one else, I have a last question to Francesco about his free movement comparison, that European integration was about free movement. If you read Article 29, Treaty on the Functioning of the European Union, you will see that products from third countries shall be in free circulation if the import facilities and conditions have been fulfilled. So that, in a way, presupposes some sort of entry clearance, doesn't it? And that's the end of the question session, unless we have someone else, but we do not. And then we move back to the panel in the reverse order. So we'll start with Antoine, and we'll conclude with Francesco.
I do share some of his concern, indeed. As a negotiator, you, time to time, you lose a little bit sight on how you are going to implement the regulation that you have discussed about. But I believe as well that... Sorry. I believe as well that one should not lose sight as well on his role, and indeed the Commission has the right to initiative to all the legislative process, but as well as the guardian of the treaties and the guardian of the EU law, and maybe it's time as well for them to be serious on that role. So yes, but I don't have the answer. There is a big risk indeed that the certain countries are not going to respect. They are going to violate the EU law on that matter indeed, but they are already doing it. We are trying to find a solution for maybe the one that needs it the most, so the frontline member states and the destination member states. And yes, and I don't really know how to have them on board. I believe, and it goes a little bit about your the question on the return sponsorship. I believe the Commission has proposed this return sponsorship only to get certain member states on board and to try to find the consensus. That's why it's so complicated, but it's only because those member states have stated so vocally that they just want to talk about return and the externalization of the asylum policy, and that's it. So it was one of the means that they use in order to maybe find a compromise. Is it a good one or not? I don't really know, even though I have a slight idea on that, a small idea on that. Thank you.
Merci. And Gabriele from Roma next.
Thank you very much. I have not heard all the questions very well due to some audio problems, I think, but I don't think I was actually addressed by any of the questions, if I'm not mistaken. I would just like to thank you again for the very interesting debate, and I would just like to say that we believe it is now time to truly address migration as a key EU issue, and to really try and foster dialogue on all aspects of this very complex problem. And with our ultimate goal should be to create a reform that can fully implement Article 80 of the Treaty on the Functioning of the European Union, that is the principle of solidarity and fair sharing of responsibility. So thank you again.
Thanks indeed for this diplomatic answer. We talk a lot about national interests, but I think your intervention just showed again the mere fact that we are still negotiating, or that you are still negotiating, is maybe a positive sign that Europe hasn't fallen apart yet. We'll move on with Florian.
Okay, I try. It's very interesting, challenging questions. So starting with bilateral readmission agreements and the relation to sponsorship, I can also refer here to the work of Jean-Pierre Casarino, who has made this database on all the bilateral readmission agreements. It's very useful there. As far as I understand, the relationship is more indirect. I mean, the Commission says we can go ahead with whatever means we have to bring people back to the country. Bilateral readmission agreements are welcome. I think it has become less critical if member states actually pursue bilateral agreements. Sometimes it was seen to be at the expense of European Union readmission agreements. Right now, I think they see it a bit less critical and say, but then they should use the bilateral, leverage, bilateral agreements also for a European purpose, and then can possibly even use migrants from the same country from other EU member states to bring back. I think that's a bit the spirit that is in mind right now. Second question, the third country cooperation and sanctions in the visa code. So we have 3 countries, as I mentioned, Bangladesh, Iraq, and Gambia. And if you look right now in the discussion in member states, you can see even here that it's relatively discussed, in particular the Iraqi case, and Denmark has here some objections because they seem to have quite a good cooperation, bilateral cooperation, and they fear that there is an issue if it's sanctioned, because EU-wide it's considered insufficient, so it's always this balance between bilateral interest and wider European interest. I also talked to a few people from Gambia, what they think. In Gambia, there were some protests against flights containing migrants from Europe, and Gambians said, return is a mass issue in this sense because of this protest, and they say there are so few people traveling to Europe with a regular visa. Those people who are traveling, they often have multi-entry visas, and they are also less concerned. So it's a relatively small number of people being concerned, presumably by visa sanctions, and the pressure created by such measure will probably not compensate the domestic pressure and domestic mobilization against return flights. But it's not yet decided, but it could be an indication of how in third countries the debate is evolving. The third question, what is the purpose of return sponsorship? I think Antoine has given already some very good indications. I do believe as well there are primarily political reasons to have developed these projects. There needs, or the Commission believes there needs to be some signs for border states that the others are helping, and relocation proved impossible. So it was a kind of a compromise given the restrictive priorities of some member states. Another reason what I see is that, and this we have heard throughout the debates, it's so much on numbers. The whole debate is always boiled down to few numbers, and I think then if you can show that you bring away people, concrete numbers, it's also an argument in a political debate. I think, Francesco, what you're asking is really what is it achieving in terms of, as outcome for the people, and there certainly you open up much more problematic areas. So I think the real benefits from a policymaker's perspective are political, and showing that you're capable of doing something, showing that you try to support, but to obtain what, you can have certainly a very critical perspective there. And what is, final question, what is happening after a transferred somewhere? I mean, that's a big issue. In many states, we have right now really the illusion that people who are supposed to return will be returned, and the regime or the transfer towards a regularized status is getting tougher and tougher in a whole bunch of member states, I believe. So I think here you really create vulnerabilities. You create also a lot of pressure on the migrants themselves to finally leave voluntarily. I think that's a bit of a purpose. So there will be, if the pressure on third countries is not successful, you may enhance the pressure on the migrants themselves. I think that's a bit the logic behind it, but I mean, you can be very critical from a human rights perspective or from the perspective of dignity or whatever you want. Stop here.
Merci, Florian. Miss Romeo.
Thank you. So the question was about whether the European Commission did an impact assessment of the border procedure and if they had the same results of me or not. Well, the answer is no. To my understanding, the European Commission never did an impact assessment. At least in May, when I published the study on which my intervention were based, I could find none. The European Parliament Research Service published instead a very extensive research on border procedure. I think probably some of the speakers today had participated into it, maybe Professor Cornelisse, if I'm not wrong. They didn't use data in the same way that we did. But if I remember correctly, the main conclusion was that border procedure, even when they are carried out on quite low numbers, always, human rights and procedural guarantees are quite never respected. When the European Parliament adopted this report, their wording, they said that the non-respect of human rights and procedural guarantees was intrinsic to the border procedure. So, yeah, I hope this answered to your question.
thanks also to you. And we conclude with Francesco.
Thank you so much. I'll take the various questions I've been asked in turn, starting from Madalina. Well, Greece, you tell me, is a bad performer under 267 TFEU in general. Well, then the infringement procedure should bear on 267 in general. Doesn't mean that it's okay not to have references in the asylum field. By the way, I am an EU lawyer, and I cannot think of an area in a member state where EU law is most intensively litigated or on a larger scale than asylum law in Greece. And yet no cases, so no applicants raised any relevant doubts of interpretation or validity of EU law throughout the tens of thousands of procedures that have been going through there, even though we know that there are several aspects of Greek practice that are, to say the least, problematic in respect of EU law. Well, I'm ready to believe this on the presentation of conclusive evidence. Otherwise, I really have a hard time believing that. To Galina, you asked a question I don't know how to reply. My assumption was that persons become subject to return sponsorship once there is a return decision pending on their head. But Your Honor, I need permission to adjourn and to give you the final answer another day. But you pointed out a very stimulating hypothesis, that the whole concept is that the sponsoring member state will be better at returning the person than the one that is doing this. That would be interesting to think of, but I see no element that makes me think that it would be automatically true. There will be many states offering return sponsorship because they don't want to have to offer relocation immediately, but that may be terrible at then returning people. So worth discussing. Iris, I can only express agreement to the fact that one of the main problems is that we've lost sight of why it is that we have a common European asylum system in the first place. No doctor ordered us to do this. There is a competence in the treaty, but there have been competences that have gone unused for 30 or 40 years. Again, your common European transport policy took a long time to get there. And we are losing sight of the fact that there are strong functional reasons to have a common European asylum system in the true sense of the word once you have a common travel area. So I agree. Daniel, products from third countries move freely only after entry clearance. We both know we got to be very careful with analogies, but I'll take yours. And well, I say that there has to be some form of mobility upstream or downstream of status determination. And now you give me an opportunity to elaborate 1 minute more. As far as Dublin or its substitutes are concerned, I'm all for no transfer or consensual transfer, but I fully accept that it still has to be qualitatively different from free movement. So when I evoke free movement, I'm mostly talking about beneficiaries. And what is status determination procedure but glorified entry clearance, I ask you? So if we apply the analogy, we should be going for free movement all the way. Last point is to the answer that Florian gave about return sponsorship. Thanks, and yes, so I agree. I see that we all share the thing that return sponsorship is a product of what you call realpolitik, Daniel, right? Realpolitik approach. But my point is that reality is not confined to the reality of the council negotiating room. There is also a reality outside. And in that reality outside of the council negotiating room, the proposal makes no sense. Unless Galina is right, that the other state is better than the first state. But it has to be one hell of a lot better to justify the whole business of embarking in this kind of transfers inside. And I think I pointed out because this is the illness of which suffer our whole debate on solidarity in Europe. It is completely divorced from the realities of the field. Let me quote a quote that Gregor Knoll made in 2001 at the beginning of his seminal article on Dublin. I don't remember from whose the quote was. It was a very exotic thing. So I'll just quote Gregor, and you go looking for who was the author of the phrase originally. The phrase was, Babylon takes its abstractions for realities. I think it still applies.
Thanks indeed to all 5 speakers for thoughtful and also very precise presentations and comments at the end, to the audience for very insightful questions, and also for listening carefully. If you do not ask questions, we have not resolved the solidarity conundrum. I think that was unrealistic to expect of us, and we are all actually quite happy that we do not sit at the negotiating table, because that conundrum is very difficult to resolve. Officially, we do not have a break, but I have been authorized to give you up to 5 minutes for getting some fresh air or doing whatever you deem appropriate. We'll reconvene at 5 past 5.